Hello, everyone. Welcome back to the Public Law Parlour, where I, along with my co-host Alexander Ramdas, discuss all things public law related. Now, I know that you would have missed us for quite some time, and we do apologize for that. That was primarily due to some work commitments that both Alex and I had, quite some busy people, one more than the other. But we're back here now, and we want to be as consistent as possible with the publication of these episodes for the podcast. So today we're going to be discussing an issue that has been gaining quite a lot of traction within the legal sphere and also the international sphere recently. And I will pass it over now to Alex so that he can essentially lay the foundation of what we're going to be discussing today because it is right up his alley and his area of expertise and interest. So, Alex, over to you.
Right. Hi everyone. The Public Law Parlour has not been cancelled, and I've been getting a lot of messages if Rico and I have just decided to end on a peak when we interviewed Justice Saunders, now retired president of the CCJ. Um, but no, as Rico mentioned, we were both very busy people, one more than the other, that one being Rico. Um,
Absolutely. I was referring to you, sir. But
but but today we are going to discuss the Inter-American Court, sorry, recent advisory opinion on state obligations under the Inter-American Convention to address climate change. Now, I'm sure if you've been keeping up with the international sphere or the international sphere generally, you'd know that in the last year, there have been three very important advisory opinions released by three very important international tribunals, that being the International Tribunal on the Law of the Sea, the Inter-American Court of Human Rights, and recently the International Court of Justice. Um, each of these courts would have been asked to identify state responsibilities or state obligations under their respective conventions to address climate change. Um, each of those opinions are very long, and it is not our intention to go into them individually. What Rico and I intend to do today, for the purposes of this podcast, is to narrow in on the Inter-American Court's opinion on climate change, because we found that there are some interesting developments in the Inter-American Court's jurisprudence that can affect the right to a healthy environment and the interpretation of the right to a healthy environment in the Commonwealth of Caribbean. Um, as you would know, well, as you all should know, that there are only two countries in the Caribbean right now that have codified a right to a healthy environment in their constitutions, that being Guyana and Jamaica. However, many Caribbean countries have already signed and ratified the Escazú Agreement, which is an American convention mostly concerned with access to information and access to environmental justice and those things. However, one of the provisions of this agreement is that the state parties are required to incorporate the right to a healthy environment into their domestic law. So, given that the Inter-American Court has now issued this very interesting, in some parts amazing, some parts revolutionary, some parts controversial opinion on what state obligations are under this right, we thought it was necessary to sort of explore and flesh out how this right will interface with Caribbean constitutions as they are. Um, so, firstly, I think it would be useful to identify generally what the Inter-American Court has said about the right to a healthy environment. Now, for those of you who don't know or don't follow environmental law, the right to a healthy environment has been considered a right that is fundamental to the existence of humanity. Um, Obviously, because for humans to exist on planet Earth, there's a need for our surroundings, our environment, to be in a stable, safe state. Now, the Inter-American Court has said that the right to a healthy environment is an autonomous right that exists on an individual and a collective level. What that means is that on the individual level, your right to a healthy environment can be attached and relate to separate rights. This means the right to life, the right to health, the right to property, and
Personal integrity.
personal integrity, and collectively, meaning for present and future generations, bringing in principles of inter and intragenerational equality from the Stockholm Convention on Sustainable Development Law. So, so you might be wondering, what does this have to do with Commonwealth Caribbean constitutions? Now, the truth is, as you would have learned in our previous episodes, the interface between international law and Commonwealth Caribbean constitutions is a tenuous one. In the CCJ, we have a strong pronouncement in the Maya Alliance case that adopts Lord Bingham's edict of the rule of law that there needs to be state compliance with your international obligations. In the Privy Council, there is more or less a general acceptance that international obligations are useful and very important interpretive aids that breathe life into your constitutional provisions. Now, considering that these states have, well, two states in the Caribbean already have the right to a healthy environment in their constitutions, and there has been very little jurisprudence from these states emanating from the courts that has fleshed out the consequences of these rights. It's important to pay regard to the Inter-American Court to determine exactly the consequences of what these rights may have for the region. So now I'll throw it over to Rico to go into a little bit more detail on the obligations of states to comply with international law under the Privy Council and CCJ.
Yes, thank you very much, Alex, for that excellent synopsis. And based on how eloquent he is, how confident he is, you can tell that this is surely Alex's area. As a matter of fact, what I will do before I discuss the obligations of Commonwealth Caribbean states under the constitutions as it pertains to compliance with international obligations, I want to commend to our viewers and listeners a very good piece that Alex co-wrote with some leading scholars in the area of sustainable development law, discussing the three advisory opinions from the International Tribunal on the Law of the Sea, the Inter-American Court of Human Rights, and the International Court of Justice, and he wrote it under the auspices of the Center for International Sustainable and Development Law. And what I mean is the title of the blog post is quite long, so I will not state it here. But what we will do is that when we release this podcast, we will also release the link to this blog post in the, I guess, comment section, or when we post the episode in the post as well. But it's a very good piece. I myself read it. And even if you do not want to read the three prolix and lengthy advisory opinions, this would cover everything and essentially give you a bird eye's view of what transpired in those advisory opinions. So we have a leading scholar here with us on this topic, I would say. So I will do now is look at how Caribbean countries can to some extent be bound by what the Inter-American Court had to say about the right to a healthy environment. Now, as Alex alluded to, we already have the CCJ using Lord Dicklot's analysis of the rule of law, and one of his sub rules on the rule of law, we also discussed this in a previous episode, is that the rule of law requires states to comply with their international obligations, and that is regardless of whether or not the obligations have been incorporated into domestic law or not. Now, currently, we have 5 Caribbean countries who have the CCJ as their final court of appeal: Barbados, Dominica, Belize, Guyana, and St. Lucia. So for sure, we know that those 5 Caribbean countries, by virtue of having the CCJ as their final court of appeal, they are required to comply with their international obligations, which have been expounded upon by the Inter-American Court in its advisory opinion. So whatever the Inter-American Court in its advisory opinion had to say about the right to a healthy environment in the context of climate change and international human rights, international environmental law, could affect how Commonwealth Caribbean constitutions for these particular Commonwealth Caribbean countries that we just mentioned, the 5, that could affect how their constitutions are interpreted. Right? Especially Guyana, since as Alex mentioned, Guyana is one of the 2 constitutions in the Caribbean that actually constitutionalize the right to a healthy environment. But even though the other 4, Dominica, Barbados, Belize, and Guyana, do not have that particular constitutional right, by virtue of having the right to protection of the law, which the CCJ said is intimately linked to the rule of law, and both of them require those states to comply with their international law obligations, thereby the advisory opinion of the Inter-American Court could have a substantial and fundamental effect on how their constitutions are interpreted as well. Now, as it pertains to countries that have the Privy Council as their final court of appeal, the position is fundamentally different, but to some extent a bit similar. Now, the Privy Council has not adopted the radical position of the CCJ, which is that the rule of law requires a state to comply with all of its international obligations. What the Privy Council has said is that international law can be used as an interpretive aid for Caribbean constitutions, meaning that when you're interpreting a Caribbean constitution, you can interpret that constitution as far as possible, or you must rather interpret the Caribbean constitution or the provisions therein as far as possible to be in line with international law obligations. It's not to say that you're importing the obligations, or that you are necessarily obligated to import those obligations, but is only being used as an interpretive aid and nothing more. So it's to that extent that it is fundamentally different to the CCJ's position in the Maya Alliance case.
As you could see, be it whether you are a jurisdiction that falls under the auspices of the CCJ or the Privy Council, there is this advisory opinion has some value, some weight to your country, because barring Trinidad and Tobago, and a couple other jurisdictions, I don't think there are many countries that have not signed on to the Escazú Agreement, requiring the right to healthy environment to be incorporated into your domestic law. So it's important to understand the implications of this right and the interface by which the courts will have now will have to pay due regard to the scope of this right and the contours of this right. Now, the right to healthy environment generally, as it has traditionally been understood, consists of both procedural elements, which would include access to information, public participation in environmental decision makings, access to courts on environmental matters, and substantive elements. The substantive elements being a right clean climate, access to air, water, food, stable ecosystems, a stable climate, as the Inter-American Court found in their advisory opinion. But so none of that is entirely controversial or inconsistent with what is normally considered the right to a healthy environment. However, in perhaps what I think is the most interesting aspect of this case, and one of the reasons why we wanted to do this podcast today was that in addition to affirming its position of the autonomous individual and collective nature of the right to a healthy environment, the Inter-American Court took it a step further. And what they effectively did was they said that the right to a healthy environment also included nature as a subject of rights. And what that means is that for humans to exist in a healthy environment, for there to be a stable climate, for there to be a stable ecosystem, for us to have adequate access to potable water, for us to have adequate access to food and all of these resources, nature would now need the ability to actualize its rights and its personhood, effectively making nature a legal person under the law. Now, this is controversial because nature
Highly
rights.
controversial, Alex. Highly controversial. And I was about to say that you said the court took it a step further, but it seems as though the court took it steps, plural, many steps further, not just a step.
Right. So, right. And what was funny is that under the decision of paragraph 283, to as a at paragraphs 279 and 283, what the court did was that they found that nature has its right to maintain its essential ecological processes, meaning that nature has a right for its processes to exist. That means the water cycle, that means your forests, the processes that exist within those things biologically. I'm not going to pretend to know the details of these things, but nature has a right for those processes to exist, and that the state has a positive obligation to ensure the protection, restoration, and regeneration of these ecosystem processes, right? And is a controversial, as Rico would say, steps further, because the idea of giving legal personage and the ability to sue to a non-human thing is something that,
Making something that is not a person, a legal person,
yeah,
is in and of itself controversial.
it is. It is controversial, but I mean, all my cards on the table. I have no problem with it.
But
Um,
I guess what we can say, Alex, is that if under the law, and especially Caribbean constitutional law, um, uh, let's say a corporation or association or trade union can be recognized as a juridical person, even though it's not necessarily a person or individual like me and you, I guess the argument can be made that nature, which also is not a person, can enjoy these rights as well. But the
right.
question that I would pose to you and any other advocate of nature enjoying human rights is this, and I'm just being devil's
Well,
advocate here, is
is
not to say
nature enjoying nature rights, not human rights.
if it is that you were saying that nature has rights, you would have to show me where the rights of nature are outlined, right? Is there any particular document that I can go to find out what are the rights of nature to make them distinct or separate from human rights? And that then leads to my question. And I'm just putting that out there. I'm not being um in opposition to the idea that nature enjoys rights. I'm not in full agreement either, but I'm not in full opposition. I'm not sure where I stand is yet, but I'm just being devil's advocate here. And I'm going to pose the question to you as a staunch advocate of nature enjoying rights. What place then? Because if you're saying that the rights of nature are not necessarily similar to the rights of the human being, which Commonwealth Caribbean constitutions protect, is there any place for the rights of nature in Commonwealth Caribbean
Oh,
constitutionalism?
so this is what I would say, right? As you would know, there are various elements to rights, right? Um, Nature does not have the right to bail, obviously. Nature probably will never be able to to bring a claim under cruel and inhumane punishment. But what nature can do, and what companies have done, is companies can sue for perceived violations of protection of the law. Companies can can sue for violations of their
Right,
due
but
process.
on what basis? If you're going to use the right to protection of the law, Mr. Ramdas, which is a very broad and pervasive right, as
Yeah,
both the CCJ and the Privy
exactly why we
Council
could use it.
acknowledge. Right. But you see that's where my question is going.
Yeah.
If you're going to rely on such a broad and pervasive right, such as the right to protection of the law, um, to benefit nature, then what are the parameters of this right? Where does it end? Where does
Where
it
does it
end? So,
where?
on what basis would you use the right to protection of the law to give nature
No,
these
so this
specific
so
rights?
I think so. What do you mean? So remember, as the in terms of specific and detailed outlining of what nature rights entail, as I said, the Inter-American Court is perhaps the first court to go into any real detail in trying to flesh out what this means, right?
And that
Right?
is the
Because
problem. Therein
right,
lies
no,
the problem.
no, but
Because
yeah,
if
but
it is the
let me,
first court,
yeah,
Alex, if it is the first court to go into detail, what was its basis? What was the legal basis for this court being the only court to go into detail about the rights of nature? Where did it come from? Did it just fall out the sky? Is it like where? What was the basis? Like there has to be a basis for something.
no, I remember. So what they said at paragraph 273 is that the inimical to humans' rights, the human right to a healthy environment is nature's right to seek its own interest. Right? Remember, so let me finish my thing here, right? So when you right, there's an implicit link, right, between the human's right to exist in a healthy environment and nature's right to exist. Remember, nature's right to have some form of sovereignty or some form of protection over its ecological processes
I'm
is
not sure
what
about sovereignty, but you go on.
sovereignty. But when I say sovereignty, I mean ownership of, right? Because remember, by conferring legal personage to nature, right, what you are doing is you are now viewing nature as a legal entity responsible for its own processes, right? So nature's interface with the law and interface with the right to a healthy environment is no longer as an ancillary object from which we extract, right? It is now a right-bearing institution, well, not right-bearing, not institution, but right-bearing entity that can that has some form of protection that is inherent to its processes. So that's why the court said that it has a right to maintain its essential ecological processes, right? So as a ancillary or as a periphery to the human right to a healthy environment, nature needs to be afforded some form of legal personhood because it is only nature and only the environment that will be able to determine what is healthy for itself. Because ultimately, a human being's interaction with the environment will always be extractive, right? And by providing some protection to nature's ecological processes and its right to maintain its ecological processes. What you do is that you ensure that in defining the contours of a healthy environment, you are now putting nature on an equal right-bearing footing so that, for example, if it is that you now want to clear 200 acres of, well, 200 is small in the context of the Amazon. If you want to clear 10,000 acres in the Amazon, right? You you now have to interface with the Amazon forest right, or the Amazon forest ability or its right to maintain the essential ecological purpose that the Amazon serves, and the importance of all the various systems that the trees and the whole holistic um ecological system that exists in the Amazon creates, right? And that is their basis. So as a periphery to the right to a healthy environment and to ensure that humans are afforded this full extent of the right to a healthy environment, nature needs to be a right-bearing entity so that nature itself can seek its own interests. And not in the sense that nature will sue, but in the sense that the positive obligations that you owe to nature under the Constitution now are afforded to nature as a right-bearing entity and not as this peripheral thing that we exist in, that our interface with has been primarily extractive. That is how I understand, and that's how I understand the judgment when I read it, if that answers your
Okay,
question, right?
fair enough. I am not sure that I am completely convinced. But you did try your thing, and I will say thing because again, I'm not entirely convinced. But what I
But so
will
so
say is that I am also not satisfied that, as you said, there are obligations owed to nature under Commonwealth Caribbean constitutions. Again, I would have to ask you what is the basis for that. You said positive obligations owed to nature. I don't know what is the basis for that?
well,
Where
as
are you
I
finding
was,
that?
I was speaking hypothetical in the sense that
Well, you should have
would
said that.
no,
You
I
should have
mean,
said that
I was
because we don't want our guests to be befuddled,
yeah, no,
right?
well,
So if you're speaking hypothetically, then
in the
that must be
context
clear.
of the right to a healthy environment, right? You, because your question was you don't see the theoretical underpinning of it, right? And I was letting you know that the court viewed it that as there are positive obligations under international law, right? What the effect of creating this legal personhood of nature does as an ancillary to the right to a healthy environment is that positive obligations now become owed to nature as this legal person, right?
But
And
we
as you would
can't
know,
say on the Commonwealth
oh,
Caribbean
that was that. Maybe
constitutions.
I misspoke, right?
We
But
we don't know that as yet. We
we
don't
don't know
know that
that as yet. Yeah.
until a national court
Well,
says
yes,
that that is the
yes,
case for Caribbean constitutions.
yes.
We are speaking hypothetically.
Okay. Well, then I don't even remember saying the word European constitutions. But then, but then
Yes.
if I did, I am sorry. I did not mean
So
Caribbean constitutions.
I have two questions for you then.
Yeah.
So am I to understand you as saying that the protection of the rights of nature is a necessary corollary to the protection of the rights of human beings?
Um, yes, that's what that is. If you're asking what the court says, then yes. If you're asking
No,
my opinion, yes.
okay, and there's nothing wrong with that. There's nothing wrong
Yeah.
if
But
you are.
let me before we go, there's one thing that I will say about the Inter-American court's approach. While I am all for the rights of nature, there is a question of consent that needs to be ventilated here. Um, just because it is a rather bold thing when states signed on to the Escazú agreement and they said, you know what, we like this right to a healthy environment thing. We like the we like the procedural and substantive rights as they
And then
are.
automatically
Basically,
you're giving rights to nature.
and automatically you sign on to this, and all of a sudden you're like, and you see that tree over there in the Caribbean Sea,
That has a right.
that has a right.
That
I don't,
river, that river has a right. That beach,
yeah,
that beach, Miami Beach in Barbados has a right.
yep. So I am all for it, but in terms of the historical broader context of the drafting of Caribbean constitutions and the consensual nature or the unconsensual nature of how they were drafted, it does rub me a bit wrong that it is one of those things where you're now sort of forced into the corner of, well, not that you're obligated to follow it, but there's this gigantic body of persuasive law now that you can't ignore, right? And also an international obligation for many countries to sign on to ESCASM. And while I am an environmentalist and all of those things, it is something that does kind of raise a, I wouldn't say a red flag, but it doesn't just doesn't sit well. Just because constitutions by their very nature need to be consensual.
Consensual. And as a matter of fact, now that you mentioned that, international law itself is predominantly based on consent.
Yeah.
So if international law is based on consent, what would you think of Caribbean constitutionalism and Caribbean constitutions? Even more so, because there's a direct relationship between the government and the people. You just can't, you just can't unilaterally determine as a court that
Yeah.
a river or a beach or a forest or a gully or a tree has rights,
I mean,
right? So
in response
really
to
is
that,
a
I
bold
in
assertion
response
to
to
me.
that, what I would say is that, as you alluded to at the beginning of this segment, that the idea of a company as a fictitious entity with separate legal personage was also the creation of a court. That wasn't a statute that was passed. The company law emanated from the court. But the idea of a separate legal entity existing as a company is a court-created institution.
The
So I
difference
think,
though, Mr. Ramdas, the difference. I understand what you're trying to do, and if you were a judge, I would say I would call this judicial activism,
yeah,
right? Or judicial overreach, as Justice Saunders said in the last episode of the podcast.
like two
The
years ago.
difference though is that they are identifiable rights in Caribbean constitutions that can actually inure to these legal persons like corporations or trade unions or associations. I
Well,
can't necessarily say the same for nature, and that is the
oh,
difference. So
I mean,
let's say for instance, a corporation can enjoy the right to religion in a Caribbean constitution if it is a religious corporation or association. A corporation can enjoy the right to freedom of expression, let's say if it is a news powerhouse or media outlet. So these and a right to freedom of expression, again, another right in Caribbean
mhm,
constitutions. But I can't say that there's any right in a Caribbean constitution or all, as a matter of fact, that
mhm.
can then inure to nature in the same way that those rights would inure to corporations or associations,
Right,
legal
right.
entities.
Yeah, well, I think right now you so like a corporation cannot enjoy the right to life.
Right, so that's what I'm
Right.
saying. It
So
can't,
that's what
it
I said.
cannot
Sorry. So that
enjoy
right.
all.
So
There's
right. So what
some
I so
rights that
right,
a
exactly,
corporation
right.
cannot enjoy, but
So
at least there's some that they can
right. So
enjoy in Caribbean
and I as
constitutions.
I said, when you look at how we interface with the environment, right, there are rights that can annul, right? For example, the protection of the law. You might say the protection of the law is a very broad right, right? The law also requires compliance, strict compliance with with the the environmental permitting process, right? The right to life, in my mind, could ignore to nature because it also requires compliance with adequate scientific certainty and use of up-to-date
So you're
scientific
saying that
models.
nature now enjoys the right to life.
It does because what do you understand by the right to maintain its essential ecological processes?
So and that was going to be my next and final
Yeah,
question on this particular aspect of the
yeah,
discussion. Is it, wouldn't you agree that it is possible to recognize and protect what you call and what the court called the ecological processes and purpose of nature without recognizing nature as a legal person or affording it legal personhood.
I think
Is
the
it is
difference
a
is,
yes or no question, by the way?
I mean, no, it is a more complex than a yes or no question, right?
Fair enough.
As I said, remember, it is possible to recognize it, yes, right?
Without
But
giving nature personhood, right?
personage, right? But I
Good,
don't think
good,
it's
good.
possible to impose a positive obligation on the states, which is I think to me is what I draw the difference from, because the positive obligation to protect, restore, and regenerate is what the commission has said. This is part and parcel of this right, right?
And that is my point. So
Yeah.
I'm not sure that I can agree with you there. You can impose on the Caribbean constitution if the people so desire, or the particular parliament, you can impose a positive obligation on a state to
Mhm.
protect nature without giving nature legal personhood.
Mhm.
That is possible,
Yeah. Hmm.
correct?
Yeah, yeah, I agree. But then,
Yeah, exactly. So that is my point. So my my point is that maybe the Inter-American Court perhaps went a bit too far in this regard.
no, I wouldn't say so. I think I think they went fine.
But moving on, Alex.
All right.
These are the kinds of discussions, viewers and listeners, that we like to have. Um,
Ah,
so
all
moving
right.
on, Alex.
Good. All
So
right. So
we have another aspect of
the final
yes.
important aspect, which I will leave Rico to do on, because the entire reason why this podcast is 2 months late is because Rico Yearwood was doing a lot of time, spending a lot of his days researching Jus Cogens norms. Um, and the final aspect of this judgment that is actually very important is that the Inter-American Court found that there is that the nature that the obligation not to cause irreversible environmental damage to the climate is jus cogens in its nature. Um, and I will now hand it over to Rico because I don't want to misspeak on jus cogens norms, especially because we have the foremost authority in Barbados at the current moment on jus cogens.
I wouldn't say that I'm the foremost authority. I wouldn't even consider myself to be an authority at all. What I would say is that I'm quite acquainted with the area. But we first have to start off with what is a Euskogen's norm. And the classical definition of Euskogen's um norms is found in the Vienna Convention on the Law of Treaties. I think it may be Article 53. And essentially, it defines a use Hogan's norm as a norm recognized by the international community as a whole, meaning by all states or majority, vast majority of states, as being non-derogable, meaning a principle, rule, or norm that a state is not allowed to derogate from under any circumstances. Regardless of the circumstances, you cannot derogate from this norm. And therefore, it can be viewed as use Hogan's norm can be viewed as like the constitutional norms of international law, meaning that they're the most superior norms of international law. So examples of use Hogan's norms would be the prohibition of slavery. Another example would be the prohibition of war crimes and crimes against humanity. Another example would be prohibition of genocide. These are all widely accepted and recognized as the use Hogan's norms, norms that you cannot derogate from under any circumstances. So here we have the Inter-American Court and other international tribunals saying that the obligation of a state not to cause irreversible damage or harm to the environment is now a Scogans norm, meaning that under no circumstances can any state, or should any state rather, derogate from this norm. So we all have this collective responsibility and this collective duty to protect the environment. And as Alex would say, the ecological processes, etc. Now, there's also another principle in international law called erga omnes obligations, and I believe the Inter-American Court of Human Rights and the other international tribunals also spoke about this when they were looking at the obligation to protect the environment. Now, an erga omnes obligation is an obligation that is owed to all states and all people across the world. So what I usually tell people, and this is something I learned as well, and I tend to pass it on to my students, is that you may have Scogans norms that are erga omnes obligations, but you may have erga omnes obligations that are not Scogans norms. So, like for instance, we just use the prohibition of slavery. Let's say the prohibition of slavery, we just said that it's a Scogans norm because it's a norm that you cannot derogate from under any circumstances. Simultaneously, it is also an erga omnes obligation because it's an obligation that one state owes to all states all over the world. It's owed to everybody, right? But then you may have an erga omnes obligation, an obligation that is owed to all states, but it has not reached the status or threshold to be categorized as a Scogans norm, meaning it has not reached that threshold where you can deem it non-derogable under no circumstances, right? So it's a very interesting area. And so for the Inter-American Court of Human Rights to find that this obligation to prevent irreversible damage or harm to the environment, especially within the context of climate change, is now a Scogans norm. And this obviously includes the prohibition or prevention of transboundary harm as well. It's quite interesting. It's a very interesting pronouncement and proposition, I would say. So, and what I would also say is that there's a school of thought that
Well, this is exactly
suggests
where I was going because I know I know the reason why this is important is that, as you were telling me for the last 2 months, while the reason we were away because Mr. Yearwood was looking at this point specifically for the last 2 months. Anytime I
yes.
message him like, Rico, we have a podcast that to do, and he was like, Mr. Alex, no. I need to find out this point. Is that there's a school of thought that says that Scogans norms can be can form part of a jurisdiction's common law.
Automatically.
Automatically, right? So
Yes.
just to provide some context of what may or may not form part of the common law, depending on Rico's analysis, the court found that large-scale irreversible deforestation of primary forests, crucial for biodiversity, um, damage to biodiversity with massive and irreversible damage to biodiversity with massive and irreversible loss of species and degradation of critical habitats, persistent large-scale pollution of freshwater resources, release of toxic substances. All of these things are what the court has indicated they consider to be Scogans in nature and may or may not form part of the common law. So to provide context on that, I will hand you over to Rico again.
Yes. So yeah, so he took the words right out of my mouth. And the support for the proposition propounded by this school of thought can be found in, again, the seminal case of Joseph and Boyce. In Joseph and Boyce, I think it was Justice Pollard, God bless and rest his soul, Justice Duke Pollard from Guyana. He enunciated the position that Scogans norms or norms of customary international law generally can automatically form part of the common law of countries all over the world, and thereby binding those countries to those obligations. And I must say that even the president of the Caribbean Court of Justice himself Justice Winston Anderson, and let me take this opportunity to congratulate the Honorable President on his elevation to presidency. He himself, in some articles and in some cases as well from the CCJ, also supported this position of Uskogan's norms forming part of the common law of nations. So if you take this position, I'm not necessarily saying that I am in support of this position, but I'm just saying hypothetically that if you take this position, then it would mean that regardless of whether a Caribbean country has constitutionalized the right to a healthy environment in its constitution, then taking the position of jurists like Justice Anderson and late Justice Pollard, then the principle or the obligation not to cause irreversible environmental damage can automatically be incorporated into the common law of Caribbean countries, and thereby they could still have obligations in that regard, even if not under a constitution. So very, very interesting area. And I guess time will tell if these Caribbean countries do have these obligations, and if they do, to what extent? Will it be to the same extent that the Inter-American Court has said that these countries have the obligations, or would it be to a lesser or greater extent? What do you think, Alex?
What do I think? From my perspective, I think I can only speak to a Trinidadian perspective, um, where a lot of the things that have been determined to be irreversible environmental damage are things that are covered by our respective environmental management acts, our town and country planning acts, all of these things. So there is already a statutory rule that prevents large scale deforestation without an environmental permit, right? Release of toxic substances. It's also something you need to go through the water pollution rules, the environmental clearance process. I think what it is very important for is for maybe the smaller jurisdictions that do not have framework environmental legislation and framework environmental processes that may or may not know, that may or may not, even if it is large scale or in part, at least under common law, there is some obligation, one, to obtain some form of permitting before you engage in large scale deforestation, to have some form of rule or law that incorporates the polluter pays principle and all these rules of international law in terms of how you release toxins into water. All of these things. So and in that regard, I think I won't say is a matter of how much or how little. I think to me is good in the sense that I support the incorporation in the sense that it now provides common law protection in jurisdictions where there is, I don't want to say, well, if minimal environmental legislation. So even for example, Barbados, where there is no framework environmental legislation, I think there is benefit to having um, this obligation incorporated into the domestic law via common law. Not because Barbados does anything, well, not that I would know, but not anything outrightly environmentally deleterious. But there's a certain sense of reassurance that at least under common law, these protections are now existing. Um, so that's my response to your question. I don't view it as a how much so much as I think it's a good development, irrespective of the extent to which courts decide to adopt it.
Okay, okay, fair enough. And I can accept that. Well, now that you just mentioned all of that, something came to my mind, which is that there's also a school of thought which suggests that even if Uskogan's norms or norms of customary international law are automatically incorporated into the common law of a country, it has to give way to any statutory law or any constitutional law that is so clear and so unambiguous, which may be in conflict with that incorporated Hughes-Cogan's norm or norm of customary international law. So even though it may be automatically incorporated in the common law, that is not the be all and all, right? If it conflicts with a higher form of law like statute or the Constitution, then that higher form of law will override or trump the incorporated norm of Hughes-Cogan's. But what I will say though is that even though I find that the Inter-American Court made some very bold and audacious and perhaps in some instances questionable assertions in the advisory opinion, I can see the merit in, and I would support the assertion that the obligation not to cause irreversible environmental degradation or damage is a norm of Hughes-Cogan's. And I say that because a few minutes ago, I gave you some examples of the norms that currently constitute norms of Hughes-Cogan's, like the prohibition of slavery, prohibition of genocide, prohibition of crimes against humanity, etc. Now, when you look at the nature of all of these norms, it is understandable and is quite clear why the international community as a whole would not want these particular atrocities or acts to happen. It's clear why the international community would recognize these as norms which you cannot derogate from. As a matter of fact, there are people who say that Hughes-Cogan's norms are there because the prohibition of these acts would shock the conscience of mankind or humankind. Now, if these norms constitute Hughes-Cogan's norms, then for even more compelling or for a stronger reason, then the obligation not to cause environmental or irreversible environmental damage has to be a Hughes-Cogan's norm as well, because this is an obligation, if not fulfilled or complied with, as Alex said earlier, could affect the very fundamental existence of humankind. And any obligation which, if you don't comply with, could affect our entire existence, has to be a Hughes-Cogan's norm. Like, as a matter of fact, I would say it has to be the most superior form of Hughes-Cogan's. It has to be at the top, because if we don't exist, we can't even enjoy the other rights to begin with. So any norm that affects our existence has to be, I would argue, categorized as a Hughes-Cogan's norm as well. So it has to be up there with the prohibition of slavery. It has to be up there with the prohibition of genocide. It has to be up there with the prohibition of war crimes, crimes against humanity, because it is just as important or even more important, some can or may argue, right? And that is my contribution.
And after that very strong, dare I say, statement of, Mr. Yewood, you sounded like the strongest environmentalist in the Caribbean just now.
Sir, it may just mean that I'm coming to take your position in short order.
What
I'm coming for
position is
you,
that?
Mr. Ramdas. I'm coming for you, sir. Out of all the people I know in the Caribbean who are strong advocates for the protection of the environment, sir, I would say that you are up there. Right? You are up there. You're at the top, sir. We're talking fans, we're talking listeners, we're talking viewers to one of the premier environmental lawyers in the Caribbean.
To borrow a phrase of a colleague of mine, I am merely a simple man living a simple life.
Yes, so I think this was a great discussion though, Alex.
Yeah.
And
All
I
right.
think not just great, but necessary. And because it's on a very live issue and an issue that will continue to be live.
It's
Because
also
I
very
think
relevant to the Caribbean because
exactly,
we are at the forefront of climate discussions, and
exactly.
invariably the right to a healthy environment and its implications will feature. We may not all have the right to a healthy environment in our constitutions, but we are all undergoing constitutional redrafting processes. Barbados, Trinidad, Belize. We're all redrafting, and the right to a healthy environment has been tabled as a proposed right in every single one of these constitutions. So it's something to be mindful of, and the implications of which we need to be mindful of moving forward as we venture into climate change.
Yeah,
And
and
with
to piggyback on that, Alex, I would say while not all Caribbean countries have the right to a healthy environment in their constitutions, certainly we all depend on healthy environments in the Caribbean in order to survive and to thrive, even economically. And if we can't thrive economically, if we can't thrive socially, all of which are then linked back to this healthy environment, um, then again, the it will lead to an existential crisis. So I would say that yes, it's high time that all I do support, and this is something that crossed my mind recently as well. Perhaps it's high time that all Caribbean constitutions do constitutionalize and incorporate the right to a healthy environment. I think other Caribbean countries should follow suit and follow in the footsteps of Guyana and Jamaica. Because again, without a healthy environment, we can't enjoy any of the other rights in the Constitution. So why shouldn't that right be in the Constitution as well? And
so I'll
for
take issue with
instance,
that because how I mean, your right to liberty when you know,
yeah,
not to be
yeah,
deprived
but
of liberty without due process
without
of
a
law.
healthy without health, without a healthy environment, without healthy people, what good is the right to liberty? You wouldn't have a right to liberty because you probably wouldn't even be here. And
As I
that's my
said,
point.
as I said, Rico just, and they say I am the environmentalist.
No, sir, I am just a public law enthusiast who is supporting the development of public law through environmental concerns. I would put it that
Yes.
way,
And
right?
with that, with that, before Rico really comes gunning for my place and I have to resign my fellowship, this has been episode 4 of the Public Law Parlour.
Yes, thank you very
Thank you,
much.
guys.
Cheers, guys. Take care.
Yeah.